Hearing in the appeal, Privy Stuart against the Attorney General of Trinidad and Tobago.
Gentlemen, before we begin, I have to say something about the delays in this case since leave to appeal was granted by the board in March 2019. An agreed statement of facts and issues was only filed in February 2022, and by no standards is that acceptable. The board's registry asked then for a chronology to explain the delay, and this too was very late in coming. The registry had to chase for weeks, and several emails were simply ignored. So on behalf of the board, I have to register our disappointment. Appeals can only be listed, as I'm sure you appreciate, with due efficiency and dispatch if the parties cooperate fully with the registry. And we would ask that you please invite those instructing you to take note of this. Thank you. That's all I wanted to say about that. We can now proceed with the hearing.
My lords, before I proceed, please allow me to apologize for the delay. For my own part, I became involved in the matter at a very late stage, and I can say that my junior counsel had been chasing behind the instructing attorneys with a view towards getting what was required done. And we experienced tremendous difficulties. In fact, the brief was returned. So a lot of delays arose as a result of disaffection that existed between the parties in terms of the change of counsel and the different movement towards the matter. Saying all of that, I know it doesn't do very much. I myself feel personally embarrassed that that is the way that a matter must first proceed, on the basis of having to make an apology for something that is really unforgivable, and I apologize.
Right. Well, let's proceed, Mr. Coiles.
Thank you so very much. My lord, may it please you, I am Ernest Coiles. I appear on behalf of the appellant. I have with me Ms. Debbie Rupchand, and I also have with me, far away, Mr. Kevin Ratiram in Trinidad, who is on the link. Appearing for the respondent is Mr. Thomas Rowe Casey. And I'm glad I've got that through, remembering to pronounce his name correctly and to remember his name correctly. Now, let me just say how I intend to proceed with presenting my arguments to the board. First, I intend to give a brief background to the facts and the history of the matter. Brief. Next, I intend to identify the Court of Appeal's approach as to the basis upon which it considered it was entitled to intervene. Next, I will seek to demonstrate how the Court of Appeal went wrong in interfering with the learned trial judge's finding of fact on the issue on a wrongful premise, we say. Lastly, I would seek to demonstrate that the trial judge's conclusion on the issue of malice was a conclusion which was permissible upon the whole of the evidence, and it's reasonably explicable and justifiable. Having said that, I will go in now to the brief background. At near midnight, on the 27th of August 2011, when Trinidad and Tobago was under a state of public emergency, a party of police officers, including PC Phillips, attended at the appellant's residence, went to the shouts of police by one or other of their number, and the sound of banging on his door. He opened the door to be confronted with the sight of armed police officers with guns and flashlights, and of the armed police officers pointing their guns at him. The appellant was arrested, this is on the 27th, taken to the district police station. He was charged with being a gang member under the Anti-Gang Act that had recently come into force. He was refused bail as expected because under the Bail Act, a charge under the Anti-Gang Act is not bailable. And he was remanded in the custody of the state. The matter was adjourned to the 29th of September. On the 29th of September, the Honorable Director of Public Prosecutions attended the magistrate's court and personally indicated that he was discontinuing the prosecution of the appellant. It was on the basis of insufficient evidence. Arising out of this, the appellant made claim for false imprisonment constituted by his arrest, malicious prosecution constituted by the charge. After trial, the trial judge found in favor of the appellant on both fronts. On appeal, the Court of Appeal upheld the judge's findings and conclusion as to the false imprisonment charge, accepted that with respect to the malicious prosecution, that there was no reasonable and probable cause, but differed on the basis of there being malice, a necessary element in the tort of malicious prosecution. Now, the sole issue before the board on this appeal is whether the Court of Appeal was entitled to reverse the trial judge's finding on that issue of fact, namely malice. That's the sole issue. It's a very narrow issue. Now, in dealing with the matter, the Court of Appeal first recognized that to reverse findings of fact by a lower court, the Court of Appeal must identify a material error in the judge's evaluation of the evidence which undermined the judge's conclusions. I'm referring to page 334 of the electronic bundle. It's the Court of Appeal's judgment, paragraph 12 of that judgment. The court rightly recognized that there must be a demonstrable flaw in the process by which the trial judge reaches finding. The court considered that the flaw in this instance, or flaws in this instance, were that the trial judge failed to analyze the evidence in its entirety, one, and secondly, drew inferences which were not justified. You'll find this at page 335 of the electronic bundle. The court found that the trial judge had misconstrued the evidence of P.C. Phillips and made errors, which errors were said to be that the learned trial judge, Justice Charles, she wrongly concluded that admissions were inconsistencies, wrongly imputed that P.C. Phillips had fabricated evidence, and further wrongly imputed malice in P.C. Phillips' decision to charge the respondent. So there are two grounds, bases, upon which the Court of Appeal felt itself entitled to intervene, and in intervening, to reverse the trial judge on this issue of malice. Looking at the first issue, that the trial judge failed to analyze the evidence in its entirety. We say that the Court of Appeal proceeded on a wrong assumption. The court twice made reference to the trial judge's alleged failure to consider the evidence of the appellant. And I refer to paragraph 15. It's at 337 of the electronic bundle. It's at the top of the page, and I'm reading. While the judge was correct to hold, she did not analyze the evidence in the manner required, including failing to consider the evidence of Stuart, except on the issue of damages. That is the reference that the Court of Appeal is referring to, that the judge did not consider Stuart's evidence. It wasn't said once, it was said twice. It burdened the court. And at paragraph 29 of the judgment, which is at page 348, the court repeated this claim. 348, paragraph 29. Yes. So that I'm on page 348, and I'm reading the paragraph. It's at the end of paragraph 29. It then fell to the judge to assess Stuart's credibility and that of P.C. Phillips and ASP Mohammed, and come to our conclusions having regard to the evidence as a whole. While the evidence of P.C. Phillips and Stuart was critical to the issue of reasonable and probable cause, the judge also had to weigh Stuart's evidence in the balance. This she did not do, except on the issue of damages. Now, we say that that is a fatally wrong assumption, and we say so on the basis of the guidance that is given to appellate courts as to concluding that a trial judge has not considered the whole of the evidence. And of course, it's in that very well-known case of Henderson and Foxworth. In that case, it is expressed that an appellate court is bound, unless there's compelling reason to the contrary, to consume that the trial judge has taken the whole of the evidence into his consideration. Now, we say this
particular evidence of Mr. Stuart would be relevant here.
I would say the evidence that he is not a gang member. In fact, let me just make it, if we can look at electronic bundle, page 45, paragraph 17, this is what Mr. Stuart says. At no time was I a gang member. I was never involved in any illegal drug use, possession, or sale from 2010 to the present. I have never sold drugs at all. I was never involved in the sale of narcotics with my wife or Coben Stuart. It's supposed to be Kevin. In fact, Coben Rock and I have never been on good terms with each other. He and my wife have 2 children together. Mr. Rock and I do not even speak. So that would be evidence that there was no basis for charging him with being a gang member. And it would have been perhaps up to the respondents to decide, listen, are we going to put Mr. Phillips in the box or not? They had that option. They could have decided. In fact, the Court of Appeal, in the same paragraph I referred to before, 29 at 348, in this case, the appellant chose to rely on the evidence of P.C. Phillips and ASP Mohammed, and they were presented for cross-examination after the respondent was himself cross-examined. It then fell to the judge to assess Stuart's credibility and that of P.C. Phillips and ASP Mohammed and come to a conclusion having regard to the evidence as a whole. So the judge is talking about looking at the entirety of the evidence, but assuming that the learned child judge failed to take into account the evidence that I just referred to. And earlier, the court expressed that this whole question of shifting burdens, there's a shift as to how we have to look at that. Don't look for the claimant to set up the case, and then whether or not, there is evidence to raise this whole question. You must look at everything in the round. If I can take you to paragraph 29, which is at page 347. And this is what the learning says. It says in Gibbs and Ray, the Privy Council considered this issue of shifting burdens. That was an appeal which concerned the thought of procuring the issue of a search warrant without reasonable cause and with malice, a thought akin to malicious prosecution. And Gall Jane given judgment, and I'm reading from the last 3 lines of the page, the preferable, perhaps I should read the entire thing. The other aspects on which some comment on approach of the judge is appropriate is that of shifting burden of proof. The lordship finds such terminology unhelpful. The preferable approach is to consider the matter in the round and determine whether the evidence as a whole satisfies the standard of proof. So this is why I say, there was a choice that the state could have made. Don't call any witnesses, or don't call P.C. Phillips. But once it is the state undertook that obligation to allow P.C. Phillips to give evidence, of course they did it to lead some evidence, to discharge their evidential burden. so that in the event the court had no evidence, the court could have easily considered, listen, accepting the evidence of what the appellant had said, I've had no evidence at all from Phillips. I'm accepting that there was no basis at all for a charge of a gang member. So that is the basis, the first premise. That I say was a wrongful premise on the part of the Court of Appeal in assuming that the trial judge did not take the whole of the evidence, and in particular, the evidence of the appellant into account.
Well, I mean, the material evidence would be the evidence as it appeared to PC Phillips, wouldn't it? Rather than what Mr. Stewart's own belief might be.
No, I think the way in which the Court of Appeal was looking at it, it was first of all saying, the Court of Appeal, what I gather from what the Court of Appeal is saying, the evaluation of the evidence must be of all of the evidence. Because this is really, we are talking about an appellate jurisdiction. It's about all the evidence. And I think the point that the court was making is that the judge focused only on PC Phillips rather than, as she was required to do, look at all of the evidence. And in
this would have been significant. It can't have been a criticism of her that she didn't take account of his evidence that he was completely innocent of anything. It can't have been a criticism made that the judge failed to take account of evidence given by Mr. Stuart that he was completely innocent of any wrongdoing. The criticism, if there was one, must be that there was evidence that he gave which was incriminating in some way, but we haven't seen the transcript. Was it put to him, for example, that he had a string of previous convictions?
It's accepted that he had, I wouldn't quite call it a string, but yeah. I would certainly say that he had his fair share of brushes with the law, okay, in an earlier period. And that is to say, a period before the coming into force of the Anti-Gang Act. So yes, that is accurate. He did have one or two convictions in relation to that. We are not challenging that. You see, but what distinguishes this particular case concerning the question of convictions is that in this particular case, the Anti-Gang Act required specific ingredients to be satisfied, not just the mere fact that a person might have been involved in criminal activity. In fact, that is the entire crux of the matter. You know, it's a wrongful assumption altogether that because a person might have sold drugs before, that automatically that means that, listen here, he's now a gangster, he is a member of a gang, and he is engaged in drug-related activity, in gang-related activity.
Sorry, I thought that in his statement when you showed us, he said he'd never been involved in drug dealing, but I've just looked back and he said he hadn't been since 2010. So
yes, he hadn't been, yes. Okay, so it is my first submission, it is my first submission that the premise that the court didn't take the whole of the evidence into account is a false premise. That is my first submission. Now, the second basis upon which the Court of Appeal considered itself able to interfere was that the trial judge drew inferences which were not justified. Now, the material inference concerning the appeal is the inference of malice, that there was an improper purpose being the driving force behind PC Phillips laying up the charge, that it was an abuse of the court process, abuse of the court system. That is the inference that we are looking at. That is substantial inference that we are looking at, that the court seems to be criticizing the judge for having arrived at and inferring. The trial judge made that inference based upon her clear finding that PC Phillips had no reasonable and probable cause, and particularly lacked honest belief in charging the appellant as a gang member. Now, reasonable and probable cause includes that element of honest belief. The honest belief that you must have is that you must honestly believe in the charge that you are laying. And you must also honestly believe that there's a fit case to be tried. The learned trial judge, she questioned entirely. In fact, she did not accept P.C. Phillips to be a credit-worthy witness, to be a witness of truth. So I'll be looking at the evidence very shortly towards dealing with that whole question as to whether it was reasonable for her to have arrived at that finding. Now, to determine if the inference was justified, now, the court spoke of justified. I am saying is whether the inference was permissible. But that is just me. I'm saying that. Okay? We need to examine and analyze P.C. Phillips' evidence as to how the court reached the conclusion that he had no honest belief. Now, I'll be taking you through a bit of the evidence, because this is critical in determining whether there was, in fact, a lack of honest belief, because the lack of honest belief provided the foundation for the inference of malice. Now,
I mean, we could have a malicious prosecution case where there is no reasonable and probable cause,
yes,
purely objectively.
yes, yes.
But you're indicating that the trial judge here has made a finding
Yes.
that there was no honest belief.
No honest belief.
Thank you.
No honest belief. And I would help right away. I would speak on it a bit later, but eventually, in terms of honest belief, there are 3 references in the learned trial judge's decision relative to this question of honest belief. It's at paragraph 26 of her judgment, which is at page 262 of the record, the electronic bundle, paragraph 47, which is at page 272, and paragraph 49, which is at 273. And just choosing one, I will choose the last, paragraph 49, just so that we are clear that honesty featured very heavily, very weightily in the judge's mind as to whether there was reasonable and probable cause. And it is this. I'm at paragraph 49 and at page 273. It was incumbent upon Police Constable Phillips, as instructed by Assistant Superintendent of Police Mohammed, to obtain evidence of the claimant's involvement in offences against the Anti-Gang Act from the date that it came into force. No such evidence as could form the basis of an honest belief that the claimant was involved in gang activity was produced by the defendant. Now, there's a lot of drilling down to be done with respect to this, but for the moment, I'm just referring to it so as to identify that the court's concern was in relation to the element of honest belief in the charge and that there's a fit case to be tried, upon which she found herself able to make the inference. Of course, this is not denying that the court also found, on the objective basis, that information on its own was not sufficient basis for having reasonable and probable cause.
But why couldn't that be sufficient basis for having an honest belief?
Why it could not be?
Information be a basis for an honest belief,
Yeah.
even if it was no objective, reasonable basis. And I find it hard to see why she's saying that, acknowledging that there was apparently that there was receipt of information. And I can see why she says, well, that can't establish reasonable, probable cause, but why couldn't it form the basis of an honest belief?
Because for the belief to be truly honest, there must be something that is known by the officer that could support it. And dealing with that question, based on that question, I will deal right away with that aspect of the matter. Yes? Now, let me take you to P.C. Phillips' evidence. Yeah, what page is it again? One minute, please. What's it?
starts at 152, isn't it?
When is this?
That's evidence in
I'm ready.
examination starts at 154.
So, excuse me? 1 minute.
The references Lord Hamlin was giving was page 152 of the electronic bundle
154.
is where we understand the transcript of Phillips, policeman Phillips begins, and 154 is where he is cross-examined.
I see. I'm looking firstly at his witness statement rather than, yes. Yes, that's at 43. I'm looking at the paragraph.
That starts on 49 in our bundle.
Stuart is 43. Yeah.
What is it? Does he want to show? Yes. Oh, I'm not seeing it on mine. Yes, please. I'm sorry. At page, I'm sorry. Yeah. At page 50 of the electronic bundle. Now, everything that has been said before relates to historical events and what people told him and informants told him. But at paragraph 7, we are talking now about the Act has come into force on the 15th of August, 2021. At paragraph 7, this is what he says. Sometime around the 20th of August, 2011, I received information from several informants in the area who gave me certain information, which included the claimant had sold drugs to them and was a member of a gang. That's what he is saying. Okay? This is the first direct date that he is given concerning this receipt of information. And he says that on the 27th, that is the very day they went to arrest him at his home, he had also received information. Now, what the court is saying, and what I referred to earlier, is that, listen, in order for you to have an honest belief, you must have, as you were told to do by your superior, some direct information, knowledge of some activity that the appellant might have been involved in, that involved him in gang activity. And the court is saying that simply saying, out of the blue, that you got information on the 20th, and you also got information on the 27th, is just not sufficient to come to an honest belief. Unless you are very, very, very susceptible to accepting whatever is said. The information, as both courts indicated, you know, in order for there to be an honest belief or a belief in it, who gave you the information? How reliable was that informant before? How many times had that person given you information that was credible? But if it is that you could simply come and recite, will I get information? Say nothing about the information, why it is you would consider it to be something that you could rely upon or not. And on that basis, because the law provides that information is something that you can rely upon, that you seek to rely upon that so as to satisfy the requirement of honest belief, then this is an officer who is really just receptive to anything that he hears, simply because it assists in relation to what his purpose might be. I think, and I wanted to give some emphasis to this. The court is seeing this witness. The court is hearing this witness. The court is observing the witness give evidence. And the court is making a very clear statement based in that position that she enjoys of having that advantage of seeing and hearing the witness. That, listen, if you want to tell me that you have an honest belief, tell me that after the coming into force of the act, you observed something, you went and you saw something. And then you could then come and tell me, well, listen, apart from what I saw, what I witnessed, I have a good informant who told me such, such, and such. But that is not the evidence that is before the court, and the court is making it very clear that it cannot pass muster with her, that you simply come and recite. You have information.
Am I right in understanding that the judge did accept this part of PC Phillips' evidence, that he had received information from unnamed informants?
No, I don't think the court accepted anything that fell from his mouth. And I will come to that very shortly. The judge in this case made it very clear that this witness was not creditworthy in the least, that she was believing nothing that he was saying, that there were too many discrepancies.
So when the trial judge says at paragraph 49, no such evidence which could form the basis of an honest belief that the claimant was involved in gang activity was produced by the defendant.
Yes.
You're showing us a witness statement that does indicate that there was evidence, but you're suggesting that what the trial judge should be interpreted as saying is, well, I just didn't believe that evidence.
Well, that is one aspect of it. I'm saying that, but I'm also saying that when the judge is speaking about this honest belief, she's referring to the lack of a particular type of evidence. You see, the evidence was that the constable was instructed by his superiors to go and surveil and come to a conclusion, see whether this person is involved in some sort of gang-related activity, as being a member of a gang. And the court is saying, listen, he doesn't follow the instruction. And secondly, there is no evidence from him that he engaged in any such surveillance so as to be able to have information that he would have himself witnessed to support an honest belief that the charge was a good charge.
Is there a particular part of the judgment you're referring to?
I'm referring to that same paragraph 49.
49?
Yeah. 49, if you look at page 273 of the bundle, because 49 is on a different page, okay? The numbering is on a different page.
But I don't find it difficult to imagine that some police officer who go around talking to people be told that this person is engaged in drug dealing, and on the basis of that form a belief that he had been. He may have had a totally inadequate basis, but I don't see how it can be just said without more that he couldn't have had an honest belief.
I am saying, yes, if it is that the information is he's involved in drug dealing, okay, let's say I accept that. But that is not the offence with which he was charged.
Well, as long as he's collaborating with at least one other person, I think it does amount to gang-related activity.
I agree with you. I agree that that is totally accurate, and I will deal with the question as to whether...
Can I just stop you? It's okay, it's more in the middle.
Yes.
You know?
Yes, I'm sorry. I'm sorry. Yes.
It's easy done.
Yes.
Just try to be more.
Thank you. Thank you. Yes. Yes, I accept what Millard has said, okay? But I am saying that as I continue to go through, I will show that he didn't even have the numbers right in relation to there being a gang. I will come to that as I continue to go along.
But you've shown us the witness statement of PC Phillips,
yes,
page 50 of the bundle,
yes,
where he does specifically say he received information from informants,
yes,
that the claimant was a member of a gang, and he gives details of who the other gang members are, his
yes,
wife and Kerwin,
yes,
Rock.
Yes.
So his evidence was that he received from unnamed informants,
yes,
information which did directly,
yes,
support,
yes,
the charge ultimately brought, yes, of gang membership.
Yes. Yes. So,
and again, so his evidence seems to say that there was some material which could be capable of supporting an honest belief, not a reasonable belief, but an honest belief if he accepted that. And at paragraph 50 in the judge's judgment,
yeah,
this is page 273,
yes,
she seems is this not right to be accepting that there was receipt of information from unnamed informants? Because she's making the point, merely having that can't support a reasonable and probable cause to arrest. Yeah. Are you saying that we should read her judgment as not having accepted this part of PC Phillips' evidence at all?
I will say yes. I will say yes.
But, well, how do you explain paragraph 50 then?
Paragraph 50?
50 of the judge's judgment.
That the mere receipt of information without more cannot establish reasonable and probable cause to arrest?
Yes.
Well, I will support that by saying the first thing I would say is that the Court of Appeal itself concluded that the mere receipt of information cannot form the basis of reasonable and probable cause. So there's no appeal against that.
No. But doesn't that way of putting it involve accepting that there was receipt of information from unnamed informants?
Yes. 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 There could have been receipt of information from unnamed informants.
Right. So how then can the judge say that there was no evidence which could form the basis of an honest belief on the part of the claimant when he has given evidence derived from unnamed informants which goes to gang membership?
I think yes. I think what the judge is actually saying is that she cannot accept that evidence without supporting an honest belief, without the respondent himself, the PC Phillips himself, having seen something which would support the information that he has got.
But she doesn't say that the mere receipt of information cannot establish an honest belief, and she couldn't have said that, could she?
Didn't say that. She didn't say that.
No, so hasn't she really gone wrong in paragraph 50 in missing the point that she needs to confront if she's going to find malice?
But I would want to say that paragraph 40 and 50 must be read as being linked to each other. And really, what the court is actually saying is that not having got any direct testimony from him as to any observation that he might have made close to the time of the act having come in force, that she cannot accept that he could have formed an honest belief. Okay, and that this whole question of receiving information doesn't satisfy her, that it could give him an honest belief. That is what I understand her to be saying.
But why can't, why couldn't one form an honest belief on the basis of what you're told by someone else? It might not be a reasonable belief, but if you believe the person that's told you the information,
well, Millard,
it would be an honest belief, wouldn't it?
The only answer I can give to that is that it depends on how stupid the police officer is. You know, if it is that we want to say that anything that is told to him he'd believe, and he's as stupid as that, okay, then I suppose there's no argument that I could raise that an honest belief cannot come from the dumbest officer's acceptance of something.
You've got to look at an honest belief in the context of a charge.
Yes.
In the circumstances of the rest of the evidence. So if there's absolutely no other evidence at all, and you've been told something by an informer you don't name, and it's not admissible at the trial, I'm not certain how that can amount to an honest belief. But if you have some other evidence, for instance, past involvement in drug dealing and something else, I don't know. Why can't the fact that you received information give you an honest belief in the other aspects of the case?
Yes, I understand and accept what you are saying, but at the end of the day, what I am submitting is that the court made a very clear statement as to how she considered this witness, and she made a statement to the effect that she had no belief in his credibility or reliability. And I am saying that based on that, there is a basis for saying that even the evidence of getting information, the court is not willing to accept.
Do you say there was a basis for finding in paragraph 51 that Assistant Superintendent of Police Mohammed and Assistant Commissioner of Police Fredericks were motivated by indirect or improper motives?
Please help me. Say again, please.
In paragraph 51, the judge found that not only Constable Phillips, but the two superior officers were motivated by indirect or improper motives. Do you say that that finding can be sustained in relation to those officers?
None of my submissions would connect to something like that, no. I am focusing strictly on PC Phillips because that is the person whose mind we must look into and whose motives we must look into.
But doesn't that rather shake one's confidence in the judge's findings that she has made what on any view you accept are totally unjustified findings of malice on the part of two other individuals?
No, I wouldn't put it that way. If it is that the court could have taken into account their motives, I would say it would have supported her conclusion. But the fact of the matter is that their motives are not really...
I just don't understand that. If you have a superior officer who is malicious and instructs you to bring a charge on a malicious basis, and the junior officer brings that charge, surely his motivation has been adopted by the junior officer. And
well, the senior officer has caused the charge to be brought, so it would be a clear case of malicious prosecution.
Well, we've got to establish that the junior officer aligned himself with the malice.
Well, could I bring you back to my Lord Legate's point?
Yeah.
Do you accept that there is no evidence that the senior officers were motivated by indirect or improper motives?
I do not accept that, but what I am saying is that whether they were or were not is not really relevant, in my respectful view, to the motivation of PC Phillips.
But assume for one moment it is relevant.
Okay.
Do you make the case that they were motivated by indirect or improper motives?
Oh, yes. Oh, yes.
And what are they?
I beg your pardon?
What were the indirect or improper motives, and what was the evidence to support it?
The indirect and improper motive really was that Trinidad and Tobago was under a state of emergency.
Yeah.
And what the police were doing is that they were rounding up people who had criminal past, putting them before the court, so as to have them off of the streets, out of the public, and in the custody of the state. A whole host of cases were brought because the police were going around on what was described as hot spots and picking up people with criminal past.
Round up the usual suspects.
Okay,
Round up the usual suspects.
Well, anybody who could possibly, during the state of emergency, take advantage of everybody having to be inside while they are outside. So that really is really what was taking place.
And was that put to either of the senior officers?
No, it was put really, at the end of the day, it was really put to PC Phillips.
Well, was it put to him? Can you show us where it was put to him in the evidence? That?
Yes, I would try to do so right away. 1 minute, please. Yes. If it is that we were to go...
I mean, your case, quite simply, is PC Phillips received instructions from his superior officer to round up the usual suspects and charge them. I was just wondering whether that was put to PC Phillips or to any other witness.
No, I'm trying to help in relation to that. In relation to that, if we can go to page 177, 179. Okay, 1 minute. First of all, before we go there, can I just point to page 166. In fact, this is an agreed fact that the Republic was under a state of emergency. So I needn't trouble you to find it in the actual notes of evidence. Yeah? So what we have here, you are aware that on the 21st of August 2021, a state of emergency was declared in Trinidad and Tobago. Correct, sir? Are you also aware that the Anti-Gang Act came into force some 6 days prior to that? Correct, sir? Would you agree that upon the state of emergency being declared, you and other police officers who you interacted with began arresting people pursuant to the Act, correct, sir? And he's asking about whether he is pressured. Then let's go to where he's putting his case. I'm at page 179. And it says, I put to you that at the time you charged the claimant, you had no evidence he had been a member of a gang on the 27th of August. In fact, you initially arrested him because he was known to the police as having a criminal past. That was the real motive for his arrest. And then there's the issuance of the word repeat. I am saying you arrested him initially because he was known to the police for having a criminal past. It was based on his past and not what you actually saw. So that it was being put to the police that the reason for all of this activity on their part, and in particular charging this gentleman, was because he had a criminal past. And there being a state of emergency, having this criminal past, being charged, you'd be denied bail, and so you'll be out of circulation. So we could bring peace.
So the state of emergency was caused by what? General crime.
Yes, crime. Cannot handle the crime. And as I said before, without saying too much, the police were picking up people in what they call hot spots. That there are some places called hot spots in Trinidad. And going there with open tray vans and herding these people onto the vans and toting them off. And this is why, it explains why the director himself appeared at the magistrate's court, because he had to do that pretty often. Almost all of the people who were picked up, I wouldn't say almost all, I want to say all, but I don't have the statistic, were freed.
So how long did it last, the state of emergency?
I am not certain, but if I am to go from my recall, it was at least 6 months. At least 6 months.
And were there then a lot of malicious prosecution cases?
Yes. And Mr. Ratiram was involved in a lot of them. That happens in Trinidad. When you win one, you become very popular. Yes. So that this is what the judge was also saying, that when the senior police officers, when they look at the file, when they eventually look at, they immediately realize that there's no basis for a charge. You see, so that it was so poor, whatever was collected was so poor. But of course I'll come down later on as I'm dealing with malice to deal with that, but at the end of the day, there was nothing that could have been useful in a prosecution under the Act for being a gang member. So this is a matter of public notoriety. The court would have known this. The judge lives in Trinidad, she's aware, and matters of this kind would have been before her over and over again. So that there is a basis for her considering the evidence in the light in which she considered it. So I want to go back to, what is there in this evidence that caused the judge to so disbelieve that P.C. Phillips had any ounce of honesty in him? Now, it starts off with the question of surveillance. And I'm at page 155 of the electronic bundle. At page 155 of the electronic bundle, you see that the time frame that is given for this alleged surveillance, and I'm using the word alleged because the court eventually used the word alleged surveillance, indicating in my mind that the court didn't quite accept that there was a surveillance. Alright, the period of the surveillance is alleged to have been between August, was given in evidence as being August 2010 to August 2011. That is where he starts off in his evidence. But then he's confronted with, but wait, in your witness statement, you gave a different time frame. So we go to page 116. And at 160, in paragraph 6 of your witness statement, you said surveillance from around February to August 2011.
I'm so sorry, which page did you say?
I'm now at page 160, please.
Sorry, I thought you were taking us to his witness statement.
No. I am now at cross-examination.
Sorry. Okay, sorry.
Yeah.
Well, he's referring to the witness statement at the top of the page.
Yeah. Okay.
Yes, I see. Yes, thank you.
Yes, so now he's confronted with this paragraph 6. And what does he say? Right? So which is it? Is it from around August 2010 or was it from February 2011? So he has shifted now the period. He was given it a larger period under his cross-examination. But when he is confronted that, hey, it's really, from the very year. Okay.
Well, I wouldn't have thought that was the strongest point, the fact that he makes it, 8 months or a year. I would have thought rather stronger is the fact that he claimed to, we can see on that page, to have searched his premises with warrants, which he was unable to identify, and the fact that he claimed to have chased him on several occasions, but he always got away. And yeah, exactly.
It's appalling. I'm coming to it. So that's the first thing. And his answer is, I must have misaveraged time. That's his answer at page 160. You see? Now, before I move on, I want to say that the court would have been aware that with all of those extracts that the state had used to show that there was this surveillance, and this is at electronic bundle, page 54, about 20 or 25 extracts. None of them made mention of the appellant being surveyed. None. And worse, only one referred to PC Phillips being part of the party driving around in the area. One. And even in that instance, there's no reference to the appellant being the subject of any observation. So the court would have been aware of that. This was a question of surveillance, and you have put in all of these documents. But where can you show me that Phillips was the subject of a surveillance? None.
Was there any documentation produced in relation to the charge? I mean, was his written report produced? Or?
A report was produced, and I'm coming to it. Okay, I'm coming to it in relation to the question that he says that he went and he interviewed the appellant's wife. And in this contemporaneous report after the charge, there's no mention of him doing that at all. But I'm going to be coming to that in due course when I'm dealing with the numbers to make up a gang.
Okay.
Yes. So that he is off there and getting more to the more exciting part. He starts off by saying, now this is nowhere in his witness statement. It is nowhere in his witness statement. At page 154, he says, in answer to Mr. Ratiram, the then expert.
So, page number, sorry?
I'm with you at page 154. 154. I gave chase to arrest the plaintiff, who I observed to be selling narcotics. That is before the 27th of August, before that eventful midnight. He had given chase before, having observed him to be selling narcotics. Now, I want to make the point immediately before I forget that right through his cross-examination, he distanced himself from seeing any transaction involving the appellant dealing with narcotics. right through his cross-examination, he distanced himself from that. But at this page 154, he comes up with something that has never been said before, and something that would have been certainly relevant to put in your witness statement, that he had seen this fellow, you know, as this big drug trafficker, if I can use that description. And in looking at that, what does the court have to deal with? He doesn't swear a warrant for the arrest of the appellant on any of those occasions. Incredible, incredible, incredible. He knows where the appellant lives. He has seen him engage in drug activity according to him. He has chased him and failed so that his feet couldn't do it. He didn't seek to use a warrant that would have achieved the purpose. Appalling. More than that, he says, well, all right, so you didn't go for a search warrant, for an arrest warrant. Well, did you go for a search warrant? Well, now he introduces the evidence. Well, yes, I did that. He said, well, how many? He said he did it 4 times. And again, on all of the occasions that he executed a search warrant, he came up empty-handed in terms that there were no drugs to be found. So this is touching on the question of honest belief, you know. Honest belief, you are hearing about so much drugs, and he's a drug trafficker, and he is involved with other people. 4 occasions you go there, you get no drugs. So his own evidence is destroying the basis of him having any honest belief, unless he doesn't believe himself as well. So we come to no search warrant. Again, well, where are the search warrants? Well, I can't find them. I don't know where they are. This is what a judge has to be dealing with in a courtroom, hearing a police officer give evidence of a matter where the range of evidence that you need to give is a narrow range. And again, there was also that on the night, he says that he searched. We challenge that, but don't matter. You search. Again, nothing was found. So how are you forming this honest belief when at no time you see in drugs, getting drugs, connection with drugs? When he is asked, well, you don't think it was important to mention these failed attempts at running him down in your witness statement because you saw him having drugs? His answer is, feeble, I must have forgotten. Well, I don't think it's important to put in your witness statement, okay, that you had done a search. Well, I must have forgotten again. Well, according to what you are saying, you made notes of your observation on surveilling the appellant. This is at page 161. He said that he made notes, and I'll be coming to that at page 161. When you did surveillance, you would see the claimant giving things to people? He says yes. And receiving what looked like money? Receiving something. I can't say what it was. And he asked by the lawyer, but in full view you can't see? And then he asked him, did you make a note of these observations? He said yes, in his personal diary. And we'll have something to say about that shortly. Didn't you think it important to put it in your witness statement that you made notes of your surveillance? And okay, it didn't come up. This is the witness that the judge has to be dealing with. And to accept something as being truthful from him. So this is the point that I'm making. Now, let's go further. Let's go further. Now, the question of the personal diary comes up. I'm looking at, I'm saying it early, page 159, page 161, and page 164. Because all of those deal with the question of notes in this personal diary. And again, this judge is a judge who sat in the criminal court and has sat in the criminal court. All right, so she would know about police officers and police officers' evidence. And she would also know about not making notes in your pocket diary or in any official police document and making it in your personal diary, which you always lose. The court will know that. The court will know that. You can't find it. is lost. Okay? So that we have to be very careful that the judge is sitting in a very privileged and advantageous position in relation to what she is hearing. So he says, I'm at page 159, please, that he interviewed the claimant's wife. He's saying that he interviewed the claimant's wife. 1 minute. Yes. And he says, that is at, of course, I should tell you, that is at page 159. Now, this interview of the claimant's wife, he says at the same page that he made a note of the interview. Did you make a written note of your interview of the claimant's wife? Yes, I did. Where's the note? In my personal diary. This is what he says. It's in his personal diary. Let me stop there for the moment. I draw the board's attention to the fact that while he is saying that, and that he made this note in this personal diary, in his contemporaneous note at EB, Electronic Bundle, page 52, paragraph 15. That is the note he made after everything was said and done and everybody chatted to. There is no mention at all. There is no mention at all in that note. The note, I'm told, is at page 88. What about paragraph? I see. Yes, I'm sorry, I misled you in saying 52. That is really the reference in the witness statement to the note. So it's really page 88. He goes through saying all that he has to say, but significantly, not a mention of this supposed interview. And we have to remember too that when he is asked, well, what was the lady's name? Well, he can't remember. He don't know. He doesn't know her name. And of course, the surveillance is supposed to have been taking place also of her. So he can't give her name. This is what the judge has to be.
So this is this his written report we're looking at?
Yeah,
so-called written report?
Yeah, which he said that he put into a written form.
Yes.
Yes.
And is this the only document that goes to the senior officers on the basis of which they say there's no evidence here?
Yes.
That's the only document.
That's the
right?
only document.
So the file consists of this half a page document?
Yes.
Yes. Okay.
So this does, again, refer to information that he was receiving from informants.
Yeah. That's a recitation.
And just on whether the judge accepted that information was provided to him by informants, I was looking at paragraph 47 of her judgment.
47, yes. Yes.
Where in the latter part of paragraph 47, this is electronic page 272,
Yes.
the judge makes a very particular point about information relating to the involvement of the claimant's wife.
Yes.
And the judge makes the point that the fact that he was not prepared to rely on the information he received that the claimant's wife was involved in the trafficking of drugs and gang-related activity lends support, in my view, to the conclusion that he either had no such information or that he did not consider such information to be reliable. So that seems to relate to informants telling him that the claimant's wife was involved. But the judge doesn't go wider than that and say, and they're just, I don't believe his evidence that he received information from informants relating to the claimant.
You are correct. I would accept that, but I would continue to say, as I continue going through, that at the end of the day, I think it's pretty clear from the cross-examination and how the judge treated with the cross-examination that the judge didn't accept anything that was coming from the mouth of P.C. Phillips. And I would say further that, you know, judgments have told us that a judge might not be able to say everything. Judges have hundreds of cases to deal with. And it could well be that there are certain things that might not have been said as perfectly as they should have been said. There are certain things that might not have been mentioned. But we are not to assume, based on things not having been mentioned, that the consideration didn't go through the judge's mind. Because the judge is there to find facts. And this is what she's doing. She's finding facts.
But the reason
it mightn't survive, you know, closest scrutiny, you know, but we must accept that the judge is aware of the law that she is seeking to apply and that she has given consideration to the matter in the context of what is required. Sorry?
No, the reason that I drew your attention to that passage in paragraph 47 was to suggest to you that perhaps one needs to read paragraph 50, which we looked at before, in the light of that.
Yes.
That the judge is accepting that part of P.C. Phillips' evidence where he says that he received information from unnamed informants which identified the claimant, not his wife, but the claimant, as being involved in gang activity. Would you accept that that's a fair reading of the judgment?
I am unable to make that connection. It could be so, but I cannot make that connection. After I've looked too closely at the cross-examination, and I have looked too closely at what the judge said at paragraph 45, where she makes it very clear. This witness's testimony was riddled with so many inconsistencies that I do not consider him to be either credit-worthy or reliable. Now, that is a most damning assessment of any witness. And with such an assessment, I don't think that, you know, a judge would make such a sweeping statement as to assessment of a witness, but for the fact that she has found that this person is not an honest person. I cannot accept what you are saying, sir. I am rejecting what you are saying. You are coming here to recite rather than coming here to tell me facts. So I related straight back to 45.
But isn't it right, as in paragraph 45, the judge is focusing on his evidence at trial, whereas you've shown us, page 88, a contemporaneous document prepared by P.C. Phillips at more or less the time of the arrest or shortly thereafter, where he refers to receiving information from informants.
Yes, first, I attempt to be clear. A police officer making a charge would have at least a basic rudimentary knowledge that, listen here, information is something you can rely on. Isn't that stupid? So that he is going to include in whatever statement that he is given, that he has information. But we have to go beyond what is written as form to see whether we could accept that there really was a receipt of information. And that is why I'm saying that the court is looking at and considering that I cannot accept what you are saying, which includes this question of information. I think the court, in particular with respect to the wife, you know, was simply drilling home, you know, the incredulity of the P.C. Phillips having interviewed the wife. That's what she was really trying to drill home. You don't know his name, you can't recall her name, you don't consider her to be a gang member based on information. This is how I'm seeing the judge, you know, processing it in her mind as to this whole question of honest belief.
He also mentions here several attempts to apprehend
Yes.
him before.
Yes, 10 times failed. Yes.
I think the point was made that wasn't in the witness
It
statement.
wasn't on the witness statement.
It was in this document.
Yes. It's not on the document either, did he?
It is.
It is?
It is.
Yeah, it is.
About halfway down.
Yes. It is, yes. Now, I want to go further with this question of notes. Now, in saying that he had made this note in his personal diary concerning his interview with the wife,
Just taking you back to this information from informers, I can see that that would lead to an honest belief in making a charge. If you actually understood the informers would be giving evidence. But that isn't part of the case here at all.
no. The court, I'm trying to show how the court was abreast of what was taking place in her courtroom. Because the witness is asked, well, did you hand over all your written materials to the state attorneys for this case? And he answers, I'm at page 159. Well, apart from my personal diary extracts, I believe so. Apart from my personal diary extracts, I believe so. He hasn't said anything as to why not, but he's saying for the moment.
So page number again?
It's at page 159. Yes? So, having said that he has handed over everything except his personal diary extracts, the court now has a concern, and the court inquires, did I just hear him say that apart from his personal diary extracts, I believe so? Now, being familiar with court, when a judge makes an inquiry like that, it is showing a little concern and alarm in our mind. As a, oops, don't tell me this is another case where the extracts are not available, you know. So she very early wanted to make sure that she heard right. And it was confirmed, yes, you have heard it right. You have heard it right. You see? And then, the next note that he is said to have made is this note about observing things on the surveillance at page 151. Did I say 151? I really meant 161. 161. And this is where the kicker is coming. Yes. So he speaks about what he is observing, and remember I had mentioned that he is distancing himself from seeing drugs. Okay? He is saying, I can't say what it was. You get a full opportunity there to say, well, listen, it's drugs. Well, one of the 10 times that I saw him was drugs. But no, distancing himself, receiving something, I can't say what it was. Did you make a note of these observations? Yes, in personal diary. You handed over these diaries to the state attorney. Diary couldn't be located, sir. So, again, this is the type of witness the judge has to be dealing with. You just spoke about you hand over everything except your personal diary. You don't say that you didn't hand it over because you lose it, but it has to be drilled out of you that this is your explanation for not handing it over. How honest are you? How frank are you? How much trust can I place in what you are saying? Are you, walking between the raindrops? That is what is clearly coming out from this witness. And of course, the point is also made, you didn't think it was important, I've said it before, that you misplaced the diary? No. You didn't think it was important to give evidence that you made notes in it, but you misplaced it? No. So again, the court is dealing with a very difficult situation in relation to the honesty of this man and her ability to place any trust in him. But it doesn't stop there, because there's another opportunity. I'm now at page 164. And this is the cross-examination. were you able to arrest any of the people that the claimant sold drugs to apparently? Yes, sir. They interviewed them? Correct. They told you, well, I just bought drugs from Peck. I'm reading from my notes. I'm trusting it's all correct there. Correct. Anywhere between 5 to 6 people. You receive any statement from them? No, sir. Okay? No note in station diary. Okay? And then he goes on to say, I made notes in my personal diary. Now, why do I draw reference to that? Why do I draw reference to that? I draw reference to it because it is very interesting if we look, first of all, it is not in the witness statement. This whole thing about people buying drugs from Peck and telling them that is not in the witness statement. It's new. Yes? And secondly, when we compare what was pleaded, what formed part of his witness statement, it creates a large measure of doubt. A large measure of doubt. Let me just get it. If I can take you to page 21 of the electronic bundle. Page 21 of the electronic bundle.
Could I just clarify one thing? And that is the single document at page 88. The senior officers, prior to deciding not to continue with the prosecution, didn't make any further inquiries.
No.
There's nobody said, by the way, what did you see when you were on surveillance? Nothing like that at all. Yeah.
Yes. I'm at page 20.
Might have known by virtue of the oral indications that had been given to him.
Yes.
Yes, as to what he saw.
Page 21. It's a very confused up sort of paragraph, but we'll try to read it. It's at page 21.
21.
Yeah? Starts. From around February to August 2011, police officers, including Police Constable Phillips, conducted surveillance exercises approximately 100 meters.
I'm sorry, this document is what?
This is his defense, the defense of the state.
Yes, thank
So
you.
it is really relating to PC Phillips. Yeah? Yes, they conducted this exercise 100 meters from the claimant's premises, which included positioning themselves in order to capture persons who were purchasing drugs from him. These persons would sometimes be found with narcotics by police officers. I'll stop right there. He doesn't say found by him. He says these persons would sometimes be found with narcotics by police officers. When you go to his witness statement, which is at page 50 of the electronic bundle, paragraph. Yes. Paragraph 6. Paragraph 6, please. He's trying to give evidence in relation to what he was pleaded. From around February to August, conducted surveillance in marked and unmarked police vehicles at the claimant's residence, Marabella, on many occasions previous to his arrest, the claimant's arrest. And I and other officers also conducted surveillance exercises approximately 100 meters from the claimant's premises, which included positioning ourselves in order to capture persons who purchased drugs from him. We would sometimes find, so now he uses not police officers, as was first said. He now seeks to put himself in as one of the persons, you see, who would sometimes find persons with narcotics. So that the point that I'm making, it's a bit confusing, but the point that I am making is that this witness and this witness's case undergoes changes towards suiting the convenience of what might be considered to be useful towards showing reasonable and probable cause.
Which of the station diaries which are referred to in the pleading
Which of the
refers to station diaries on this aspect?
page 21 referred to station diaries. Were they ever produced to record any of these movements?
No station diary extract.
We have some. You showed us some earlier.
Yes, but those related to simply driving through by the police officers. And as I mentioned before, but for one, it involved PC Phillips. And even when it involved him, there was no reference to the appellant.
But do the station diaries establish that persons had been stopped and narcotics found?
No. Answer no, with respect. So as I say, the court is dealing with hearing all of this evidence, and having to come to some assessment as to what credibility she could attach to the witness. But I go now to the question of the gang, because remember, a gang must have at least 2 people. That's just information, at least 2 people. Well, let's see whether we have at least 2 people. We can exclude the appellant's wife immediately, because he is saying quite clearly, that he didn't think that she formed part of the gang. Although there was a very clear statement at page 157, the gang was the claimant, his wife, and Rock. And he says, correct. Yes? And he's asked, you would see the claimant apparently engaging in the sale of drugs, seen making interactions. He's distancing himself from drugs and drug-related activity, interactions. Yes. So I'm dealing with the question of the gang. And when you go to page 158, what caused you to believe that she was part of a gang? He says, information. And then he goes on, I did not believe I had sufficient evidence. He was asked, well, why didn't I arrest her? He didn't believe he had sufficient evidence at the time to arrest his wife. So therefore, at that point, he's admitting that he had insufficient, let's use the word information, insufficient material upon which to consider that the wife formed part of this 3-member gang. Excuse me 1 minute, please. What's it? Yes. So that is, so we now have worked ourselves down to 2 people. Well, let us see now what it is that he has with respect to Rock. Let us see what he has with respect to Rock. 1 minute, please. We would find that at page 168. And as we are finding it, remember, Rock had 2 children with the claimant's wife. Remember, the claimant is saying, that is not my friend, we don't talk. And that is not so unnatural. That's not so unnatural. He has no dealings with Rock. The claimant has said that very clearly, the appellant has said that very clearly. So let us see what is the evidence that is being given ocular proof of, relative to Rock. He says, during your surveillance, did you ever witness any interaction between the claimant and Mr. Rock? Yes. What? Conversation. Conversation. No drug activity, nothing involving any sort of illegality. Conversation, which, as we say, we still dispute because we don't talk to him, because how I expect me to talk to him concerning my wife? And then the question, that led you to believe they were in the drug trade? No information. And then he goes on, so you never saw the claimant and Rock exchange anything? No, sir. So again, this witness is having ocular, as I would say it, visual proof that is against his information. That is against what is being told by people who we don't know and we don't know how reliable they are. He is seeing that. It's against it. And are we to accept that, notwithstanding what he is saying and there being a lack of any material upon which he could conclude that there is a gang and that the gang involved these three people, that information would prevail? This is where we are. So it is my respectful submission that even in relation to the question as to the basic need to have at least two people as a gang, it is not established in the cross-examination of the witness. Now, let us see how the court is following the case. The court is following the case. The court is not lost. The court is paying attention to what is taking place, and the court is following the case. And I would ask that we look at electronic bundle, page 180. Page 180. And this comes after the witness has been cross-examined and he has been re-examined. What does the court ask? The court puts it this way. There's one question that I wanted to ask. It related to the evidence from the witness that prior to the 27th of August, on several occasions, he had seen the claimant giving something to some persons and receiving something in return. And you formed a view that on those occasions that you observed, that he was engaging in the sale of narcotics. That's a very incisive question. Is that your evidence? That is correct, my lady. That is correct, my lady. Now remember, that is evidence that he had never put in his witness statement. Remember, that is evidence which he is basically, right through his cross-examination, denying that he saw anything exchanged that he could recognize. You don't know what it is. It's something. Okay? But he says, that is correct, my lady. No problem. The court follows up. And you also said in answer to counsel in cross-examination that it may have been on 4 or 5 occasions you were able to arrest the persons who gave something to the claimant and collected something in return. Yes, correct, my lady. All right, well, this is a knockout punch. Prior to the 27th of August, based on all of this that you saw, did you ever swear a warrant for the arrest of the claimant? No, my lady. Now, that is what is in the court's mind at the end of the cross-examination of this witness and re-examination. To me, advocate attorney could better have asked these questions and sit down, because this goes straight to the heart of the matter. And it is based on that we are able to understand the court's assessment of the witness at paragraph 45, that the witness's testimony was riddled with so many inconsistencies that I do not consider him to be either creditworthy or reliable. She was saying that he's a lying witness. That is how we would express it. He lied. And more gently, he's not a witness of truth. That's how we express it. And if that is the court's assessment, then it is not too difficult to understand that the court would not have found him to have had an honest belief. But the court didn't stop there. The court went on to expose her thinking and her mind concerning all of this that she had heard. At paragraph 47, this is what the court says. Paragraph 47, second sentence, is about 4 lines down. The fact that this officer throughout his testimony, attempted to buttress, strengthen, and fabricate new evidence against the claimant, is a strong basis for concluding that he fabricated the case against the claimant, and in fact he had no reasonable probable cause. That is what has come out of cross-examination of the witness and the assessment that the court has made concerning the witness. Now, someone has raised, well, what are the lies? What are the lies in the dark? Someone has raised that. Well, I want to shed light. I will tell you the lies. Yes. Remember, she says, it is fabricate new evidence. Well, what's the new evidence? The officer saw the appellant selling drugs 10 times. That new. Yeah. And all that followed from that. New. And that he chased him down, he couldn't catch him, and he didn't swear no arrest warrant. Oh, new.
Sorry, can you just summarize what you say was new?
Sorry, it is, the first thing that is new is that the officer saw the appellant selling drugs 10 times.
Yeah.
And I'm saying, following from that would be, he attempted to capture him 10 times and failed. That he never saw an arrest warrant for him.
Well, that's not new evidence.
That's not new?
No, sorry, the arrest warrant.
Yeah,
The fabricated evidence,
yes,
you say, is that the appellant selling drugs 10 times
Indeed.
and attempting to catch him 10 times.
Yes.
Yeah. The lack of a warrant
Yes.
goes in support of that evidence.
Yes.
So we just want the list, as it were, of the fabricated evidence.
Understood. Thank you. I'm sorry.
Was arresting the other persons, was that new, or did that come before? He claimed to have arrested people who he saw dealing with the claimant.
That's new. Okay?
Did he actually arrest them? He just said that he stopped them, did he, or not?
No, he said arrested.
He said arrested them, yes.
He said arrested and interviewed them.
I see.
Yes, that's right.
And what new too is this whole question of making notes in his diary? And what mightn't be so new because it's stale is that you lose the diary. But it's new on the evidence.
And also interviewing the wife.
Yes.
That's fabricated.
That is fabricated. Okay, but
it was open to the judge to come to the view that it was fabricated evidence.
yes? Now, it is, in my respectful submission, based on assessment that P.C. Philip lacked all credibility, he concluded that he had no honest belief.
But the Court of Appeal said that this was just a failure to record certain events in his diary or to include them in his witness statement, as opposed to fabrication. What do you say about that suggestion?
Please help me again.
The Court of Appeal,
Yes.
paragraph 30,
Yes.
said that it was a mere failure on the part of Constable Phillips to record certain events in his diary
Yes.
or to include them in his witness statement.
Yes.
But it was a quantum leap to go to fabrication.
Well, I think I said something about that in my written submission. Let me see if I could just find it quickly. Yes. Okay. I want to be clear. I will be dealing with this as I come along, but I'm going to answer immediately. What the judge, the Court of Appeal said about the quantum leap, okay, it related to this question that evidence was fabricated. But, yes? Yes?
I just assumed that you were making the case that the Court of Appeal got that wrong, and that in
got
fact
it wrong.
the trial judge
Yes.
made a finding of fabrication of evidence,
Yeah.
and it wasn't just a mere omission to record certain evidence.
Yes.
You're searching the premises several times. That was new in evidence, was it?
Yes.
With search warrants that couldn't be produced.
That's correct. That's correct. Correct. Yes.
And searching the premises on the night of the...
That is also me.
You don't need a search warrant under the gangs legislation.
But you must have reasonable cause.
Yeah.
Now, I want to move now to the question of malice, because that is why we are here. You know, whether this inference of malice could have been made. Yes.
Mr. Coyles, we do need to keep an eye on the clock. We started 5 minutes late, so you've got about 20 minutes.
All right, I will, well, then I would hasten. I would hasten. Yes. And let's see. We'll just get to it. Yes. I'm referring directly now. So we are saying that the court has lost all belief in this gentleman, no honest belief. And so upon that basis, the court is saying that she is able to infer malice. Now, at page 352 of the Court of Appeals judgment, 352 of the electronic bundle, paragraph 36. Yes? The court accepts that proof of particular facts may supply evidence of both elements. It's at the bottom of the page. Proof of particular facts may supply evidence of both elements. That is to say, malice or lack of reasonable probable cause. Yes? And it identifies that if the plaintiff demonstrates that a prosecution was launched on obviously insufficient material, the insufficiency of the material may support an inference of malice, as well as demonstrate the absence of reasonable and probable cause. Now, in this case, the reference here relates to insufficient evidence. In this case, to be clear, there was not a shred of admissible evidence supporting proof of the charge lead. And the court found, that is to say, the High Court judge found, and it is to be found at page 276 of the electronic bundle. Yes, at paragraph 57. Yes, the court made it very clear. The claimant was taken from his home and his family and labeled as a gang member by the police when they clearly had no evidence upon which to do so. So it's very clear. So we're not talking insufficiency. Insufficiency is a basis for the inference of malice. But we have gone beyond that. There is not a shred. We are saying further that P.C. Phillips' alleged surveillance of the area provided him with no material for having an honest belief in the charge and laying of the charge, and for that matter disproved his informant's information, so he could not honestly have believed on the charge. More, we say the interview, which I've already referred to, disputed any foundation of the charge. Now, there's authority, and in fact it is in fact referred to by the Court of Appeal. There's authority that not taking an elementary step would serve evidentially as a pointer towards deliberate misuse of the court process. This is at page 354 of the electronic bundle, where referring to the case, I think what's the name of the case, of Juman from the board. A failure to take steps which it would be elementary for any reasonable person to take before instituting proceedings might in certain circumstances serve evidentially as a pointer towards deliberate misuse of the court process. Yes? We are saying here that the court itself identified that an elementary step of performing a surveillance on the appellant at a time after the act had come into effect would have been a step that any reasonable police officer should have taken. So we are saying that there is support for the view that the court could have inferred malice based on the failure to take an elementary step. We go further to say that without such evidence, P.C. Phillips could really not have had an honest belief in the charge. Again, malice may be inferred. I'm at page 355. I'm using the Court of Appeal's own references. At page 353, sorry. Did I say 355? Yes. Where the court recognized from an authority, malice may also be inferred from the absence of honest belief in the merits of the case. Indeed, this can provide strong evidence of malice. And again, this is exactly mirroring the position in this particular case, so that it is wrong to conclude that there was no basis for making the inference of malice. And that in the court making the inference of malice, the court had at least inferentially the fact of the lack of honest belief and the failure to take an elementary step. I'm going to move now more rapidly into the shorter versions of my arguments. There are other errors that we say the Court of Appeal committed. In my submissions, I had dealt with the question as to the quibble on whether evidence were admissions or inconsistencies. Yes? At the end of the day, however, the Court of Appeal itself concluded that whether there were admissions or inconsistencies, it didn't really matter, because the judge would have been entitled to deal with them based on the question of credibility. The court said, I'm at page 348, the inconsistencies referred to by the judge were in effect admissions that he had omitted to record certain events in his diary, but to include them in his witness statement. They went to credibility, and the judge would have been entitled to take them into account in deciding on P.C. Phillips' credibility. But they were not inconsistencies. As I say, it's a storm in a teacup, because at the end of the day, it has been accepted that it was something that the judge could have taken into account in terms of deciding on the credibility of the witness. Now, the court also went on, and I'm referring now to page 348 and 349 specifically, and I'll be staying within that area. The court identified what it considered to be admissions. I have no problem with that, okay? But then the court went on, at paragraph 31. The judge, however, concluded, without any proper basis, that these admissions demonstrated that P.C. Phillips fabricated evidence against Stuart. Now, that is not correct. It is not only the admissions, okay? In fact, the judge gave a whole list of items upon which she dealt with the whole question of the credibility. And that is to be found at paragraph 46. I needn't trouble lots with it, but I will just mention, it is in all bulleted paragraphs. Not a few of them could properly be described as fabrications. Quite a number of them have identified as fabrications.
The judge didn't actually go on to specify what the improper motive was as such.
That is true.
Did she?
That is true.
You're saying to us that if we accept that the judge has found an honest, that there was no honest belief,
Yes.
given that that appears from the way you've presented it anyway, if we were to accept your case, to be substantiated by her assessment of the evidence, that it was in some respects at least fabricated, we still have to get from the no honest belief to the improper motive. Now you're saying that's just a straightforward inference in this sort of case, and it therefore becomes that the improper motive is that they were, or PC Phillips was charging someone without honestly believing that there was any real basis for that conviction. That becomes the improper motive, does it?
Yes.
And how far is it significant, the context that you gave us about a state of emergency and so on? Because that, I don't think, is mentioned as having any relevance at all. Whereas you might have thought that if one's looking, well, why on earth would a police officer act dishonestly in pursuing these sort of charges? You might say, well, the context provides a sort of reason, but we don't find any hint of that in the judgment.
Yes.
But you say we're entitled to take account of that, are we?
I am saying it was a matter of public notoriety. I mean, the whole country was fully aware, of the state of crime in the country, that the government had taken the step of proclaiming as well, having the President, Her Excellency, declare a state of emergency, and further aware that having regard to the state of affairs in Trinidad and Tobago, there was this purpose in getting people with criminal past out of the society and being kept where they can be supervised. That is to say, jail. So, and it is an accepted fact that there was a state of emergency.
So the Anti-Gang Act is shortly before the state of emergency is declared, is it?
The Anti-Gang Act is shortly before.
Yeah.
Yes. It came on the 15th of August 2011, state of emergency, 21st August 2011.
But we've got no evidence as such linking all that together. I mean, you're just telling us that we can take notice of that. I mean, we may know there's a state of emergency.
Yeah. There is no specific indication of that, but I'm saying that the context, as you rightly pointed out, okay, it is accepted in the case by all parties that there was this state of emergency. You see, so I'm saying that that's the context. And I've not really found any authority which says that for a judge to conclude that there's an improper motive, she must identify what that improper motive is. I haven't found an authority that tells me that.
Do you get anything from page 80, which is the station diary entry of the arrest? It looks as though there was a group of police officers driving around, going into people's homes and trying to arrest them, and they picked up Mr. Stuart, but most of the others were out.
Yes. Yes, and that actually was on the 28th. They were going around and collecting up everybody with criminal past. Yes. A point I'd like to make, I am very near the end, and I hope I'm within my time. I'm very near the end, is that the Court of Appeal criticized advocate attorney for the appellant that, fabrication was not put, to PC Phillips. But we say that while the word fabrication wasn't used, the cross-examination is clear that the advocate was saying, listen here, you're making up this case. It's all make-up, and it is to be found at page 177 of the record where he was putting his case. So that we say that they learned, well, the first thing that I want to say is that while the court used the word imputation, that there were imputation against P.C. Phillip, imputation of malice, I think what really happened there is that imputation is just another word that the court has used, okay, for the court found. And we are saying that this was a finding of fact that the trial judge was well positioned to make. And that the Court of Appeal did what the authorities, yes, caution appellate courts should not do. That is, to exercise discipline restraint and not reverse a trial judge's finding based on his own review of the typewritten evidence of the witnesses in the record. We are saying that the learned trial judge's inferences and finding of fact as to malice motivating the charge is reasonably explainable and justifiable on the evidence, and the advantage enjoyed by the trial judge in seeing and hearing the witnesses. And on that basis, we are saying that the Court of Appeal was wrong to consider, A, that the judge didn't take account of all of the evidence in the evaluation of the matter towards arriving at a finding. That's the first thing that we say. I just remind that that seems to have been targeted, that she didn't take the appellant's evidence into account. I've given two references where that indeed was a wrong assumption, okay, and based on Henderson and Fetzworth. And in terms of the inference, I also consider respectfully that in using the word whether it was justified, that is a wrong mindset to look at the question of an inference in relation to this matter. It's really whether it was permissible. Because once you go into justified, you start now to look at the evidence as you see it in the record and come to conclusions as to whether it should have been done or should not have been done, whether it's right or it's wrong. But that's not the question. The proper question is whether it was permissible on the whole of the evidence. These are my submissions. I hope I have communicated it in a way that is clear, understandable, and we say that the appeal should be allowed and that the judge's order with respect to the damages, short of the 50,000 that was allowed in relation to the false imprisonment, that should be restored.
Thank you very much.
Thank you so very much.
Yes, Mr. A.
May I start just by taking the ball to the Anti-Gang Act itself, which we haven't looked at yet. It starts at page 900 in fact, of the electronic bundle. And I do so because it's important in our submission to focus on the definition of gang membership, which is, of course, the offence that was charged, and therefore it's important to see whether the evidence did or didn't disclose the possibility of an honest belief or the existence of an honest belief in that offence having been committed by the claimant. So the substance of it starts at 902, as your lordships will see. And the bits I wanted to draw attention to in particular are, first of all, the definition of gang, for obvious reasons, a combination of two or more persons, whether formally or informally organised, that through its membership or through an agent engages in any gang-related activity. Then, importantly, gang member. That's defined in several alternative ways. A person who belongs to a gang, or a person who knowingly acts in the capacity of an agent for or an accessory to, or voluntarily associates himself with any gang-related activity, whether in a preparatory, executory, or concealment phase of any such activity, or a person who knowingly performs, aids, or abets any such activity. So it appears to be sufficient to constitute yourself as a gang member that you are simply a person who belongs to a gang. And that's important because in the judgment of the learned judge in the present case, there are references to gang-related activity and the extent to which there was evidence of gang-related activity. What's needed in order to constitute you a gang member is simply that you belong to the gang. And then the substantive offence is created under paragraph, or the main substantive offence is created under paragraph 5, section 5 rather, hereby declared that gangs are unlawful, and any person, A, who is a member of a gang commits an offence. And the other aspect of it I wanted briefly to draw the...
But a gang is defined as a group that engages in gang-related activities. So you can't just be a group of people who get together. It's got to be a criminal enterprise.
You can't be a tennis club, no. You have to be...
You've got to be a drug-dealing group. Or,
yes, but the point is that to commit the offence, you don't yourself need, at the moment at which you're accused of the offence, to be in the process of drug dealing or whatever.
No, certainly.
If you're a member of an organisation which does that,
yeah,
or any of the other things in the first schedule, then you're guilty of the offence. And just to underline that point in a sense, can I take the board to section 5, subsection 5, so 5.5, which is on page 905. For the purpose of this act, it shall not be necessary to show that a particular gang possesses, acknowledges, or is known by, and then there's a long list of things that you don't need to establish, common name, insignia, flag, etc., etc.
It would always help if they were.
Well, quite. It would be much more useful if they were. And it goes on to say, any
being
evidence...
married is not good enough, anyway.
I'm sorry, my lord?
Just being married to someone isn't enough.
No, I suppose not.
Nor having conversations with her ex-boyfriend.
No, that I'd accept. But any evidence reasonably tending to show or demonstrate the existence of or membership in a gang shall be admissible in any action or proceedings brought under this Act. That's quite wide. So there is made admissible any evidence reasonably tending to show or demonstrate the existence of or membership in a gang.
That doesn't appear in your skeleton argument at all.
No, my lord.
If that is leading on to the proposition that evidence from an unnamed informer reasonably tends to show, that has not been...
No, it's not. My submissions are not to seek to reverse the Court of Appeal's finding that there was no reasonable and probable cause. The issue is about honest belief on the part of the officer, and I draw attention to this wording of the Act because, as I'll come on to...
What evidence are you pointing us to in relation to tending to show the existence of or membership in a gang that is admissible, except for the obvious one, namely surveillance or somebody who actually gives evidence in court saying, yes, he's a member of a gang?
Well, might I be forgiven for not, at this precise moment, being drawn into that debate, because it contains within it a premise, which is that I've got to show that there was admissible evidence of membership of a gang, whereas in my submission the issue actually is whether the officer held the honest belief when he charged the claimant that the offence had been committed, and those two are not the same thing.
Doesn't he have to believe that there is a case to go to court?
He simply has to be not actuated by improper considerations, in my respectful submission.
He doesn't honestly believe there's a case that can go to court. That's malice.
Clearly, if he's thought about it, and if he's addressed his mind to the question and has decided that actually there isn't any admissible evidence, but I'm going to charge the guy anyway, then of course that's malice. But that's not the same thing as saying that because on analysis there is no admissible evidence, therefore
but you're looking at what his state
malice.
of mind is at the time, and if on analysis he himself does not believe there is any admissible evidence. What admissible evidence was there?
Again, those are different questions. I accept, of course, if he himself, having thought about it, does not believe there is any admissible evidence that the offence has been committed, then a court, considering an allegation of malicious prosecution, would be quite ready to draw the inference that there must have been some other improper motive. I think in the case I gave the example of the facts of the Calix case, which was about a rape, where the only issue was who was the rapist. And once it had become apparent that there was no admissible evidence that it was the claimant, then the continuation of the prosecution thereafter could be inferred to be actuated by malice. But that's not the case that we're concerned with. And if I can...
What was there that the appellant might have believed was admissible evidence that the appellant was in a gang with his wife and her ex-boyfriend?
Well, my lord, there was the evidence which is set out in the witness statement of the officer, which your lordships find from page 48, which we set out in our case.
Well, that's information from various sources.
From various sources.
That's the highest it gets.
Yeah.
I mean, that's useless, isn't it?
My lord, it was
Not just useless, it's actually, the judge was entitled to find he just made that up.
Well, it's no part of my function to defend every aspect of the evidence that the officer gave. It would be an impossible task if it were. But my lord, we're somewhat getting ahead of ourselves in my respectful submission by focusing solely on that aspect of the matter, because the test is not, as I say, whether there was admissible evidence. What needs to be established is that that the prosecution was actuated by some improper motive, some motive other than that of using the criminal law for its own proper purposes. And in my submission, that evidence wasn't there. At any rate, there is no proper finding to that effect in the judge's judgment. Could I seek to summarise it?
If you look at the judge's directions, as I understand it, there was no suggestion he'd misdirected himself, or she'd misdirected herself in law, was there? You go to page 258. A citation from Hicks and Faulkner, and then Lord
Yes.
Denning, Ginsky and McIver, where he concludes police officers are only concerned to see that there is a case proper to be laid before the court. And that was approved in a later case. Anything wrong with that?
No, my lord, to be clear, I don't complain about the initial general self-direction on the law. Where we submit things start to go wrong is after that. Could I just seek to summarise it, my lords, in this way? That the starting point of my submission is that the presumption must be that the officer acted for proper cause. The burden of proof lies on the claimant in malicious prosecution. The fact that the charge was made but then not proceeded with does not by itself tell you anything about the answer to whether the claimant has proved lack of proper cause. The contention, or the case that there was malice...
It might do if it was so glaringly obvious to anybody. And a blind man and a galloping horse would recognise it as such.
That's why I was careful to say by itself, my lord. It depends on the facts. The mere fact that somebody is charged and then the charge is not proceeded with cannot by itself give you the grounds to say, well, there's a finding here of malicious prosecution. Malice can only be supported, in my submission, as a conclusion, by a clear and distinct and supportable finding of malice, bearing in mind what the authorities say about that being a heavy burden to discharge. And my respectful submission is that there was no such finding in the present case, or if on a proper reading of the judgment there was, then it's not a reasonable one. The judge, and this was noted, I think, in the course of my own friend's submissions, that the judge was, I respectfully submit, plainly wrong to say that there was no evidence which could form the basis of an honest belief that the claimant was involved in gang activity. There was evidence that was put before the court, and that takes the form of the material that we refer to in the case, which is in the witness statement of the officer.
The trouble was his evidence was shot apart in cross-examination. And the judge was entitled to take the view that she couldn't believe a word he said.
Well, my lord, the difficulty with that is that the judge herself doesn't actually deal with it in that way. She does not spell out the basis upon which she reaches the conclusion that in fact what happened was that the case against the claimant was fabricated. Can I if I just take your lordships to the judgment? The judge herself didn't reject altogether the evidence that there had been some information that was provided. Indeed, as I think your lordship pointed out to my learned friend, paragraph 50 seemed positively to suggest that the judge accepted that there was the receipt of information from unnamed informants. That's what the judge said there. Of course,
it has to be a case, a proper case to lay before the court. And if you have information that may very well be a good reason to arrest somebody, but then to bring a charge on the basis that you're not going to call these witnesses, these informants, but you're just going to say, oh, well, there is this information, I'm going to charge you. That's a different matter.
well,
Was there any intention to call an informant? Or was there any evidence that there was such an intention?
the question of whether an informant was going to be called to give evidence wasn't, I think, unless anyone else who's read the papers put me right on this, wasn't addressed.
But it wasn't put forward as a reason for supporting the...
No. But my lord, in my respectful submission, my lord, your lordship's question again elides the question of whether there was reasonable and probable cause, which of course does depend upon the existence of admissible evidence to make good the charge, and the related but distinct question of whether there was malice, which does not necessarily do so. One could have, in principle, a prosecution which is from the start entirely flawed, because there is never any reasonable and probable cause objectively to charge the person, but nevertheless the charge is brought honestly. I give a couple of examples in our written cases where for example, there's simply a mistake that's made about the applicability or otherwise of a statute in temporal terms, or where there's some ingredient which is...
That we be clear as to what the honest belief has to consist in.
Yeah.
My Lord Hamlin drew your attention to the elements of the offence as explained in the Glinsky case. So this is page 258, electronic, Glinsky and McIver.
Yes.
And what we're concerned with here is the allegation that there's an improper activation of the court's process. And
yes.
In order for there to be a proper activation, a police officer has to be concerned to see that there is a case proper to be laid before the court. Now, a police officer might believe someone has committed an offence in their own head, but recognise that there's just no evidence that can be put before a court to substantiate that belief. And would it not then be malice in the relevant sense if the police officer, nonetheless appreciating that there isn't evidence that can be put before the court to substantiate whatever belief he may have, nonetheless proceeds to invoke the court's procedure with everything that entails?
My Lord, yes, I think I'd have to accept that if an officer causes a prosecution to be commenced, either having thought about the question of whether there is any evidence that can properly be put before a court to support the charge, and concluded that there isn't, or simply having said I don't really care either way, then yes.
So in other words,
but
I think
effectively
you're accepting that the proper focus isn't just whether the police officer believes subjectively that the person committed the offence, it's whether the police officer believes that there is a case proper to be laid before a court, to activate the court process, which is
Yes.
what the belief has to relate to.
Yes, I think I'd accept that, my lord. But of course, in answering that question, one needs, and particularly before one concludes that an officer is on the wrong side of the line in relation to that, one does need also to look at the offence which is charged, because different contexts, and this was the point the Court of Appeal made about the fact that this was a new act and that it has some difficult aspects to it. Different contexts might throw up different issues as to whether or not, in fact, there is a proper case to go before a court. Which is why I say, as a matter of principle, I accept that if you are either, if you call someone to be prosecuted, either knowing that there is no proper basis for doing so, i.e. you may think they committed the crime, but you know that you can't prove it in a court of law because you know there's no, or you can't even properly attempt to prove it in a court of law because there's no admissible evidence, or you simply don't care either way, then I accept that would constitute malice. But there was no, in my submission, there either was no finding to that effect or there was no proper finding to that effect in the present case, which is why, in substance, the Court of Appeal was right to reverse the judgment of the judge.
Can I didn't say no finding, did they?
No, I think Your Lordship's right. The Court of Appeal didn't themselves say that there was no finding. But in fact, if one looks at the way the judge deals with it, it's, in my submission, pretty unsatisfactory, sort of at its lowest. Can I just take Your Lordships to the relevant passages? My Lord, it really starts in relation to the evidence of Constable Phillips at 41, which is page 267 in the electronic bundle, para 41. And the judge takes a few paragraphs to set out various aspects of the evidence. But Her Ladyship then goes on at 45 to make the finding, or at least observation, that the testimony was riddled with so many inconsistencies that I do not consider him to be either creditworthy or reliable. Now, to that extent, and the Lordships were taken through the cross-examination, it's difficult, I think, difficult for me to say that was an unreasonable finding on the part of the learned judge. But the Ladyship goes on to explain why, and then sets out in the next paragraph in a series of bullet points what the judge describes as the various contradictions and inconsistencies in the evidence. The difficulty with this is that the judge doesn't anywhere plainly in that paragraph set out actually what her findings are. She refers to the various things that happened in the oral evidence and the way in which the answers that were given in oral evidence were different to some extent from what was in the witness statement, or were things that hadn't been said in the witness statement, but doesn't in fact at any point, and makes various factual observations like the fact that no previous warrant had been sought, etc., etc., but doesn't at any stage make any findings about what.
Well, it would have been better if she'd spelled it out, but when you read through the way she's listed these inconsistencies, as she puts it, the clear what comes across is she's essentially saying he was making it up as he went along.
Well, my Lord...
And that's how they come across when you look. He's forgotten this. It was in his diary. Oh, the diary got lost. I mean, she may not have said, oh, well, he was making that up, but when you read it off the page, that's what she obviously thought.
Well, my Lord, it's easy to infer that, but in my submission, it's dangerous to do so as well. In circumstances where...
Well, sorry, is it really a question of inference? Because in paragraph 47, she characterises this as fabrication of new evidence. So isn't she looking at things which could have been said before but were not, and is making the point in 46, as my Lord says, in essence, difficult to believe when just made up. And then at paragraph 47, she characterises this as fabrication of new evidence.
Well, my Lord...
I mean, if she's not referring to those points when she says fabricate new evidence, what do you say she is referring to?
Well, I know. I think I have to accept she's clearly referring to material that she has set out in paragraph 46 under the heading contradictions and inconsistencies, that much is plain. But in my submission, it was incumbent on the judge, particularly to make clear factual findings, particularly in a case where she is moving to the conclusion that a witness has fabricated, in fact, she says, fabricated new evidence and fabricated the case against the claimant, and that relates to the next point I want to make about this. But just sticking for the moment with fabricate new evidence, my respectful submission is that it was incumbent on the judge to do more than the learned judge did here to explain actually what findings she was making, what evidence specifically was fabricated, because what evidence was just inaccurate factually and perhaps wrong as a matter of inaccurate factually and perhaps either the result of carelessness or dishonesty on the part of the witness. It's not good enough, in my respectful submission, for the learned judge simply to list a whole series of things that she herself described as contradictions and inconsistencies, and then at the end say, well, the fact that this officer attempted to buttress, strengthen, and fabricate new evidence is a basis for concluding, ...
Do you accept the shopping list that was set out on behalf of the appellant of the 7 bases upon which it would have been permissible for her to have held that new evidence was fabricated?
Well, I certainly accept that the shopping list, if one can call it that, insofar as it was a list of things that the witness said in evidence that he hadn't said in his witness statement, was accurate. Yes. No, my friend's right. My friend's right about that.
Permissible for the judge to have found that was all fabricated.
Yes, it doesn't necessarily follow that it was all fabricated, but I accept that. I think I'd be in difficulty saying the judge acted unreasonably. I mean, clearly, but if I'd been, sorry, my lord.
Sorry. Often you may have a situation where the judge has to quite carefully scrutinise that some parts of the evidence may be rejected as made up, but other parts could be accepted. But there comes a point, doesn't there, when the witness is so incredible and just coming out with things that the judge thinks are so implausible that she's entitled just to simply place no reliance on anything he said. And that's what she was really saying, wasn't it, at the start of 45?
Well, it's certainly what she says at the start of 45. I agree, my lord. The judge
when you come up for the first time with the fact you've carried out searches of his house under search warrants, which you've never mentioned before, and then you've no idea what happened to the warrants, and there's a long list of things like that. It just gets to the point where you think, well, this person is he's just an utter liar. I can't believe he ever had any information in the first place.
And you ask, where's the record of this? I'm told it's in a personal diary. It's been lost.
Well,
I mean, that does scrape the barrel, doesn't it, the personal diary bit?
Well, as I say, my lord,
Is he still in the police force?
I don't know, my lord. I'm sure I can find out, but I can't, as I freely accept, I can't say that the learned judge would have been acting unreasonably in rejecting those aspects of the evidence. But I do nevertheless respectfully submit that it was incumbent on the judge to do more than simply set out a series of contradictions and inconsistencies as she described them, and then set out what the learned judge set out, and simply say then that this constituted fabricating new evidence. But even if the board's against us on that aspect of the matter, it doesn't, of course, follow, as it appears to have seemed to follow to the judge, that what that tells you is that the case against the claimant was fabricated. I mean, well, this is quite an important point, because, of course, the fact that the witness...
No difficulty at all in saying, if you fabricate your evidence, you have the anterior question, whether you fabricated a case in an earlier stage.
Yes.
But it's very powerful evidence, isn't it? If you fabricate it during the course of a trial, and isn't that fairly powerful evidence?
Well, it depends on what fabrication you're talking about. The learned judge doesn't say that she doesn't actually say herself that everything that the witness said was fabricated. She says, I can't rely upon, she says he's not creditworthy or reliable, but it is a different point to say.
Throughout his testimony.
Yes.
He was attempting to buttress, strengthen, and fabricate.
Yes, but what the learned judge doesn't ever really squarely confront is what would the witness have needed to believe in order to believe that the claimant was somebody against whom there was a proper case of gang membership, and did he or did he not believe those things? The judge elides it, or the judge goes through this long list of things that are wrong with the evidence, says, "Oh, I find his testimony not to be creditworthy or reliable," says that he fabricated new evidence, and then says that it's a strong basis for concluding that he fabricated the case against the claimant. Well, in my submission, it's not, because there's a perfectly understandable other explanation for it, which is that when confronted with the fact that he's giving evidence and that he's produced a rather thin witness statement that explains some stuff but not others, the witness is tempted, on the judge's finding, to start embellishing, buttressing, and to use the word, the judge's own words, buttress, strengthen, and fabricate new evidence. The fact that you buttress, strengthen, and fabricate new evidence in support of the basic proposition that you're advancing as a witness,
well, that would be true if there was something there in the first place, but the problem here is that there never seems to have been anything other than the buttressing.
Well, except my lord, that there was the evidence of, and there was the contemporaneous evidence from the note that we saw, which itself refers to the fact that informants have named the claimant, and there was the evidence of various people there was the evidence of the existence of informants that was given in the witness statement and in the oral evidence of PC Phillips.
It's not going to be used. It's not a proper basis for laying a claim. I mean, I know that you always drive back to the burden of proof, but ultimately somebody has got to say, tell us what was the proper case to lay before the court, and that he thought he had. And it couldn't have been on the basis of informants if they weren't going to give any evidence.
Well, the question of whether informants were or were not going to be sought to give evidence wasn't gone into. One could accept that if the evidence showed that there had been consideration of whether informants would be able to be subpoenaed to give evidence or not, and it had been decided not, then you could say, well, we can discount them. But that investigation wasn't gone into. The basis upon which the judge finds malice is essentially to say, well, I didn't find that the oral evidence of PC Phillips credible. Therefore, I don't find his testimony to be creditworthy or reliable. Therefore, there is a strong basis for concluding that he fabricated the case against the claimant and had no reasonable or probable basis to charge him. And that in my respectful suspicion, is simply a non sequitur. And the judge doesn't put it on the narrow basis that, although I accept that there were informants, the evidence of those informants would not have been admissible before a court. And PC Phillips either knew that or didn't care either way, and therefore there was malice. If that was the case that was going to be advanced, then that case should have been advanced, but it wasn't, in my respectful submission.
Can I ask you this? How far on your submission are you separating out honest belief and malice? Are you accepting that insofar as it was permissible for the judge to find that PC Phillips did not have an honest belief that there was a proper case to be brought against the claimant, then she was entitled to infer malice from that? In other words, are you putting everything into the honest belief aspect of this?
I think this picks up on a question that Your Lordship asked my learned friend, I think, earlier. I think I have to accept on the authority of my Lord that you don't, as the trial judge in a malicious prosecution case, have to make a positive finding as to what the improper motive was. Provided that you can find that there was not a proper motive,
yeah.
Then you can, I mean, obviously in an
I suppose
ideal world from a claimant's
If you
point of view,
didn't have a
do
proper
need to
motive, then you must have had some.
must have had some
even
oblique
if I can't say what it was.
Yes, precisely.
It's not actually quite what I'm asking.
Forgive me,
I'm
misunderstood the
actually
question.
asking, because everything at the moment is being directed to the question of honest belief. I think these are the way
Yes.
your submissions are going. What I'm asking at this stage is, are we then to hear separate questions and issues about malice, or are you accepting that if you were to fail in relation to the honest belief aspect, then you fail in relation to malice?
My Lord, subject to anything that might occur to me over the short adjournment, which I notice looking at the clock is imminent, I think I'm driven to accept that if there was no honest belief, then it's hard for me to escape the finding of malice.
Right. Thank you.
That indeed may be a good point at which to pause for the short adjournment.
Can I just ask?
Oh, yes, since we're
over lunchtime, the inability to obtain bail isn't actually contained in the Anti-Gangs Act, is it? I'd just like to find, it must be in the Bail Act, and if that could be found, because the Anti-Gang Act had constitutional amendments. It was passed in a particular constitutional way.
Yes.
And I was just wondering whether the amendment to the Bail Act was also subject to the same constitutional rigour.
My Lord, I don't know, but we'll endeavour to find out.
Yes, thank you very much indeed, very kind.
We'll rise there. 2 o'clock.